Anything you wanted to add to this? It looks a little broader than that to me.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. Facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had, or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that that's improper. You know, what they did in this particular case, sort of what their baseline of experience is, what their baseline as far as their educational background in order to form some sort of opinion based on the facts as the jury finds them is certainly fine. But making any reference to, because it happened in this study, it must be true in this case, is something that's simply not permitted.
Okay.
If I may, just briefly.
Sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that back to his opinion or her conclusion, isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? That sounds like an anecdotal experience. But that's just me. I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I've put hundreds, if not thousands, of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know that the court can adequately rule on it. I think this may be something that we wait until the...
So let's get the list of the experts. Take a look at the Commonwealth's the defendant's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
So, Jim, let's say no action taken. All right, 27. I'll hear you, Mr. Lally.
Yes, so, Your Honor, this motion in limine is in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date. You spoke to a law enforcement agent on such and such a date, and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible. But any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does, if you mention it?
No. What this does,
explain to me why that's not so.
That's what I'm doing.
Not yet, you haven't, so please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say, in the prior trial that resulted in a mistrial, you said this?
No, but you would say, when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party, a neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am, and where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowdoin defense. Bowdoin talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important, and it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay. I'll likely rule on that today. So, number 28, Mr. Lally.
Thank you, Your Honor. So, again, similar to the motion previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regards to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement. And how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold off on that, Mr. Clerk.
Yes, Your Honor.
All right. So number 29, Mr. Lally.
So this motion, Your Honor, is essentially entitled Motion to Eliminate for Advance Notice if defendant intends to cross-examine any witness about alleged bias and request for a pretrial ruling on whether proposed evidence demonstrates plausible showing of alleged bias. So the Commonwealth is not stating that there are no statements, as the court is well aware, that could be interpreted to reflect bias and could be used by counsel in cross-examination. What the Commonwealth is not suggesting, and bless you, is for any prohibition on any statements whatsoever. What the Commonwealth is seeking here is a ruling as to what precise statements the defendant seeks to introduce in regard to that, so that the court can make a ruling prior to the witness testifying before the jury as to exactly what's in play and what is going to be admissible and what's going to be allowed, as far as, obviously it's not a perfect world, and if a witness were to answer something in a way that would then open the door for further material to come in, that's understandable. But at least a preliminary showing as to exactly what the defendant submits are the statements they wish to introduce in relation to this issue.
Isn't the defendant given broad range on cross-examination as to bias?
Yes, and that's why I indicated early on that I understand that there is that there certainly is some areas that under the law, whether or not they're true or not, are able to be explored as far as cross-examination is concerned. But what this motion simply seeks to address is there are restrictions to that. It's not unfettered. It's not, just anything and everything that they could possibly think of as say as far as accusations go.
Is there any particular type of testimony you're concerned about? I mean, is there anything in particular that you say they should not be permitted to go into? Based on what we've heard throughout the pendency of this case, is there anything? And I'm reluctant to tie the defendant's hands in any way on cross-examination without knowing exactly what it is you think is improper.
Okay. And what I would do, Your Honor, what I would suggest is similar to the other motions that we spoke of before. I can provide a supplemental with more specifics as to what the Commonwealth's concerns are,
Okay.
if the court would find that helpful.
Yes, I can't rule on this as is. So is there any objection to that, Ms. Giannetti? You're nodding.
Well, no, I think that makes sense.
Okay.
It was Ms. Little's motion.
Oh, I'm sorry. I saw you
I don't
nodding.
want to step on her toes.
No objection to that, Your Honor.
Okay. All right, so why don't you do that? So, Mr. Clerk, we'll hold off on ruling on this until we get something from the Commonwealth.
Okay.
So Commonwealth will clarify. Right, and then no action taken. All right, so as you know, third-party culprit and Bowden are often argued together, often presented together. Why don't we just deal with the two motions together? So Commonwealth's file, you're number 30 and 31, Mr. Lally. Mr. Yannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
Yeah. All right, so why don't I hear you as to your concerns on both, and as you know, sometimes third-party culprit, as it goes to Bowden, is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Yannetti? Third-party culprit as it goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be, an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Lally, go ahead. You can argue these however you want to argue them.
No, and I would argue them sort of in that vein, Your Honor. So understanding that based on the state of the evidence, as I anticipated to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as to third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of sort of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses, who have nothing to do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those, whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion the Commonwealth filed, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that if the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what their what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. This trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion. Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone, because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do it pre-trial, right? You know that today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right,
this.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a pathologist, forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
Right, so go ahead. You have your remarks.
that we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And, Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence, similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the 3 Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And, Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only 2 people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the 2 went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed, and when was he notified that John O'Keefe was dead. In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call. around the same, about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees nobody at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert. After
Right, I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages, or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here, and you've been going nonstop. Okay, let's take a 10-minute break.
All right, let's stand for a brief recess. All right.
All right, Mr. Yannetti, go right ahead.
Thank you. Your Honor, I left off with the morning of January 29th. The first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting, on his day off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote-unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth? Or
Yes.
Is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes. Between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sallyport. That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident to do the limited extraction. He never tells Trooper Buchnick or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt, and perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. The Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. Right? It's for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lally?
Briefly, Your Honor. Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these, the other thing that I would point out is counsel was counsel of record with the Finney case. The Finney case relates to third-party culprit under the Bowden event, so it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that it was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert. Just starting with Colin Albert, because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm with each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury. They testified to the exact same things in the federal grand jury, that Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's purported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the council wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally port, there's a number of different, it's a motion activated camera for the most part. The other thing that I would direct the court's attention to, as it was contained within the state grand jury proceedings, is there is cruiser camera video from the Canton police cruisers. Specifically, there is cruiser camera video from cruiser 682. Specifically, there is cruiser camera video from cruiser 682 at 8:22 in the morning when a lieutenant and sergeant from the Canton police on their own go over to One Meadows Ave, which is the residence of Mr. O'Keefe, to do a well-being check because they had not received any information as to how the children were or if they were there being attended to. And they pull into the driveway at 8:22 in the morning, directly behind the defendant's vehicle, which is exactly where Ms. McCabe parked it when they stopped there to see if Mr. O'Keefe was there, before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton, and then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Ms. Reed were present at the house. So again, I think it's a stronger argument, certainly, if we're trying to bootstrap onto a Bowdoin defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature, but there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, the car pinged at 5:30.
So hold on until you get to the microphone.
Yeah, I'm sorry. The car pinged at 5:36 p.m., indicating that it was in the Sally port. There is an outdoor camera where you can see the car about to enter the Sally port at 5:31. Of course, you can't see the tail light in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here, that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sally port. I believe that's the definition of motion, and it should have been picked up, according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Yannetti.
And I apologize, Judge. It's, according to Mr. Lally's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock? And I'll see you back here at 2. Mr. Lally, will you have Ms. Gilman, who I did see walk in here at one point, set up the screen right where we normally keep it?
Yes, sir.
Thank you.
All rise.
All right, Jim, I need just a minute with the computer, please. Okay, thank you.
Back on the record on the Karen Reed matter.
Okay, so good afternoon, counsel. Good afternoon, Ms. Gilman. I appreciate you being here. Before we see this video, just briefly, I just want to say that there were really only 2 motions that I'm comfortable with deciding by the 2 o'clock call here. Commonwealth's motion in limine of intent to obtain Corey. I don't know if I already allowed that, but that's allowed. And the Commonwealth's motion in limine, Jim, I think this is 317. Commonwealth's motion in limine to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office or FBI. So that will come into evidence the way that it typically does here in Massachusetts. You can question as to a date where the statement was made under oath, and we can discuss it as it gets closer in more detail. So the other motions are under advisement. We'll talk about that when we come back to sort of housekeeping matters at the end of the day. So do you have that video all pulled up, Mr. Lally, for me to see?
Yes, Your Honor.
Okay.
And Your Honor, for the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we, thank you.
So we locked up the house. The back door we just did the knock lock.
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure you'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death. Okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people are going to get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My tail light was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready to use your rights, okay? And I'm sure he's gonna do it again. All right, if you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I don't. I mean, I know you already know the story, so I don't need to.
All right. How long is the entire tape?
So that is Trooper Pai, who was the arresting officer from the barracks. So it goes, I believe, at least 90 minutes or so.
All right. Do you have the entire, we're not playing it now, but do you have the entire video? All right. I would like it marked for identification.
Sure.
I'd also like a copy of it so I can view the whole entire thing, put it all in context. I never like to see just sections.
Sure.
Can I get that for the weekend as well?
Oh, absolutely, Your Honor. And for the record, as far as I think a lot of that sort of preliminary stuff was more meant as context for the court. You know, there's certain discussions about court procedure and things that I don't think should be put in front of the jury.
All right, so that was my concern as well. Okay, so it's something I'll watch a few times, and the whole thing as well. Okay. All right, thank you.
Thank you, Your Honor.
For identification. Thank you very much.
Thank you.
All right. Okay, so housekeeping matters. A few things that I still need, as you know, before we have the jury here on Tuesday. I need a statement of the case. I know you have a short statement of the case in your proposed supplemental questionnaire. I think it needs to be more than that. So before you leave today, I'd like you all to agree on a joint statement of the case. I need witness lists. If the witnesses are going to be called, I have to read their names, as you know, to the jury on Tuesday morning. Once we get a jury, and I know none of us knows how long that might take, how long will it take to put in the Commonwealth's case? You can tell me with DNA and without DNA.
So with that piece of DNA, I don't think
That
that's going to
piece.
add much more than you know, an hour or two at the most. But best guess, given the schedule as outlined previously by the court, I'd say probably at least 4 weeks. My hope is there are some witnesses on the Commonwealth's witness list who are essentially testifying just in regard to administrative things, as far as, you know, work in an establishment. This is a true and accurate copy of surveillance video from said establishment.
Have you had preliminary discussions about whether there would be stipulations to authenticity like that?
No, but I plan to before Tuesday.
Okay. And you'll do that, Ms. Giannetti? You'll have these conversations before Tuesday?
I'm completely open to that.
Okay. So with the Commonwealth's case going 4 weeks, how long does the defense think their case will go?
With the schedule that the court has outlined, we're estimating about 2 weeks, Judge.
Okay. All right. I need to tell the jurors how long it will take. So if you say 6 weeks, I'm going to tell them 7, which will make it longer for us to get a jury. But
Right, understood. And then there's also the X factor of how long it takes to get a jury. Right.
Oh, exactly. No, I'm going to tell them once we get a jury, it will be 7 weeks, give or take.
And just while we're on this subject, Your Honor, does the court have any idea in terms of the availability of jurors every day of the week while we're
We don't have jurors on Fridays.
No jurors on Fridays?
No, and it gets progressively lower as the week goes on. But we've got jurors, once we start, the trial that is impaneling has priority over all other trials. So once we start, and I expect that we'll start on Tuesday, we'll do that. So there's a couple of things about the voir dire of the jurors. So we will do the voir dire, the individual voir dire of jurors over here at sidebar. And only one lawyer from each side is permitted to ask the questions of the jurors. I think I'll probably be able to give you 5 minutes or so for each witness, no more. And I'd like to talk to you all at sidebar now about your joint proposal of the questionnaire. This is something that is not public. It won't be made public until after it's decided upon and after it is presented to the jurors and they've filled it out. So a blank copy will be available then pursuant to what the law is. So why don't I see counsel at sidebar?
Is this safe, Your Honor?
Excuse me?
Is this
Yes, thank you. All right, so is that everything regarding housekeeping, logistics, things like that?
Yes, Your Honor.
Okay. All right, so we'll see you on Tuesday morning. All right, just so we're clear, there's nothing else logistically or jury impanelment, right? We're good?
I believe so, Your Honor, yes.
Okay, thank you very much. All right. Thank you, so we'll see everybody Tuesday morning.